One concern that folks have when they come to see us about an automobile collision injury case is, does this mean I'm suing? Does this mean that we have to go to court? Is that the way this must go? And the answer is no. The majority of cases are resolved without having to file a lawsuit, much less take the case to trial. The goal is, once the client is through with the doctor or doctors and is ready to talk about settling the case, then we put together a demand and send it to the insurance company and commence negotiations. It's only after that, if the insurance company is not being reasonable, that we talk to the client about the option of filing a lawsuit and taking the case to court. That is the client's decision, not ours. We advise and they decide. So you have control over whether or not you're going to be filing a lawsuit, in other words, suing, and taking the case to court. The other thing that, when it comes to this kind of thing that people ask about is, well, does this mean that I'm going after this person or am I going after their insurance? And in most cases, it's going to be insurance. That's not always the case, but it is most of the time. So it's a situation where the client has control. If there is a defendant who is underinsured, there's not enough coverage to cover the damages in the claim, and we're making a decision about, do we just take the insurance that's being offered and agree to resolve the case, or do we continue on with the litigation and actually go after the defendant and their assets? That's a decision, again, that the client makes. So we look at, is it something that you really want to do? If it's something that's warranted and it's something that the client wants to do and it's something that makes sense, then that's what we do. If it's not, then we don't. But again, the client's decision. Our job is to advise in that situation, and the client decides what's next.